Sage, who was at the Senate, joins us now for further update. He's been monitoring the motion as it played out in the House. He's now also joined by a policy strategist, Sam Amadi. We're also having, for this conversation, legal practitioner, Ejike Okpa, who will be helping with his thoughts as well. Gentlemen, thank you very much for being here. Sage, let me start with you giving us further insight as to what played out at the House today. From the video you shared with us, there seemed to be overwhelming support for the bill.
I must add, good evening, Felicity. Plenary started as usual, and then the first business of the day, of course, started with the presentation of this bill for second reading by Katsina Senator Abdulaziz Yar'adua. During the lead debate of his basic principles, Senator Yar'adua had mentioned, as a matter of fact, that Nigeria's military remains the cornerstone of Nigeria's security and sovereignty, but alluded to the fact that some of the establishment, the foundational framework establishing the Nigerian military are obsolete to the extent that it's been in existence since 1960s. Some of it comprised decrees, and the last time that the bill was consolidated was sometime in 2004, considering that that's maybe 20, 21 years ago. So hence the need, he says, for the repeal, the scrapping of the bill, and the reenactment of a fresh one. Of course, he gave additional reasons, being that the bill seeks to provide a comprehensive reform and also align the armed forces governance with constitutional principles. But then again, one thing that we have raised eyebrow of quite a number of us who observed the proceedings was when the mover of the bill, the sponsor of the bill, and also lawmakers who supported the bill, mentioning something around the areas of administrative reports and boards of inquiry not serving as the basis for conviction, but rather a trial by a court of competent jurisdiction, raising the question of whether when army officers are found to have erred and have gone through, the process of court-martialing, what happens next? Does this mean that when the bill is passed, they still have to be subjected to processes of the court, within the judicial system before, a holistic sanction or penalty is meted on them? These are some of the controversies or the questions that have been raised as a result of the bill. But then again, the bill passed second reading. The bill has been committed to, referred to the Committee of Army, Navy, Air Force, and also Defense, and they're expected to report back to plenary with the report on the bill in 4 weeks' time.
Sage, this question must have come up because we know that the first time this bill was brought before the House was in May. And then we have this situation with Wike the other day, and then there's been reactions as to what the conduct of an officer should be. The timing of the second presentation, was there any conversation around this?
I must say that during the course of conversing and bantering whether this is necessary or not, in the newsroom, we actually spoke around the area of some people connecting what happened with the Minister of the Federal Capital Territory and, of course, the naval officer to the bill. But at this point, I can only say it's a coincidence, bearing the fact that, this incident happened between 24 to 48 hours. So it really has to be a coincidence that the move for this bill to be read the second time, came. But then again, of course, not just the issue with the Minister of the FCT and the naval officer, but also questions around whether this is coming up right now because of the rumors and the issues around a purported coup attempt that we had heard earlier. And of course, we know what happened after the purported coup, even if the federal government had come out and, of course, the military hierarchy had come out to say nothing like that happened. All right. We still saw the rejig of the military defense hierarchy. So then again, speculation, but none to directly connect, the second passage of this bill to, as the case may be.
Sage, let's allow you go catch your much needed rest. Thank you for the update. Somebody, let me just jump off that. Is it a coincidence? That's on the one hand, and then from both a legal and operational standpoint, do you agree that the current Armed Forces Act requires change to bring it to reflect constitutional and global defense realities? Please check your device. I think it's muted because we can't hear you.
Can you hear me now?
Oh, yes, better. We can hear you, please. Go ahead.
So, I say first, thanks for having me. I think it might be a coincidence or it may not be. I haven't worked as advisor in the National Assembly. Oftentimes, contemporary issues may make the Senate leadership place a bill to, for hearing, for consideration. So it might relate to the moment. But more importantly, I think that some aspects of that bill good aligns with human rights. Some are overreaching, in my view, and undermines, maybe, for example, the military inquiry boards and all that have rights without court intervention to discipline and dismiss, military officers or personnel. That's even the US, that's standard practice. You don't have to go through the rigorous notion of a civil judicial trial before the military can discipline the officers. In the cases around maybe imprisonment or death sentence for alleged coup or whatever, there may be some need for significant judicial review. But the theory of judicial deference would mean that institutions like the military have administrative procedures that are not necessarily. I think some of Nigerian lawyers and people overread the requirement of fair hearing in the Constitution. Fair hearing can be depending on the issue, subject matter, and administrative body. Fair hearing for traffic offences. When you go for a license and they deny your license, that is a quasi-judicial conduct. It doesn't require the level of fair hearing that you get for criminal offences in civil court. So I think that there are some areas that I think they need to think through again. For example, areas of vesting operational control of the military over the Minister of Defense and all that. That impinges the priority. The commander-in-chief should have full, control of the military and, delegate and authorize defense ministers and other secretaries. In the US, you also have secretary of each of those who will work like administrative managers, of that system. So I think they should be very careful so that we don't assume that we have to place the military in all their segments within civil control. The military civil control does not necessarily mean that the military institutional procedure for discipline has to become as accountable and reviewable by courts as other aspects. That's not the real meaning of military civil. The military is under civil control. That's why the president is a civilian elected. And so they are under the president's control. And that's enough for civil military control. So I would argue for some level of due process review of all the proposed amendments, but they could whittle down on the prerogatives and the structure of the military as an institution.
All right, Ejike, the seeming consensus on the floor of the House was that this bill was long overdue, particularly when it came to reviewing the age of recruitment into the first persons under the age of 18 should not be in the army. But one wonders, we already have existing laws like the Child Rights Act. Why has this remained a gray area that now requires this action to unify it, perhaps?
You said in your introduction, I'm not a lawyer. I'm just somebody who has done a lot of expert witness in court. So I'm very familiar with how the court works in Nigeria as well as the US. But, back to your question, what it is that, 18, if the Nigerian government, decide that 18 is too young to join the military and they pass that law, that becomes the law relevant to them. In US, 18-year-olds are considered adults. That's the age you are right to vote. And then, or even though in Texas, for instance, you have to be 21 to be able to buy alcohol. So all of those laws and regulations they have to be relative to the area where they are going to be enforced. And so, I mean, remember, I don't know whether you were even born at the time, he dared to speak, when he was made governor of Rivers State in 1967, when Biafra broke away and the states were being created. I think he was 19 years old, and he's still alive. And he was a Navy captain or some sort of rank, and he was made governor of a state. I think in the history of Nigeria, is probably the only person at that age who assumed such a state responsibility. So when it comes to what the Nigerian Senate is trying to do, you have to separate, the role of the military and that of the civilian. Yes, in the civilian organization or democracy, you have a civilian as commander-in-chief, but there are certain conduct of the military that has to be limited within the military, laws. So like Amadi said, we have to make a distinction between a disciplinary act and a criminal act. If a soldier commits an act that amounts to the level of criminality, then where do you try him? Do you try him in a civilian court, or do you try him in a court-martial court, by peers of his own, people of his own peer level? Or if it's something that he took off his uniform and is in his village, and nobody recognizes him as a military officer, and he does things, does that amount to him being tried, in a civilian court? At that time, the court can come in and say, strip him of all that military benefits. Say, you did this while you're in Yar'adua, and we're going to try you in a civilian court. So there's got to be a distinction. In America, they have what they call the JAG, J-A-G, which is Judges Advocate General, which is lawyers in the military that practice law. So when things happen, it is done like you are in a civilian court. You have to defend your position, you have to defend your right. I don't know whether Nigeria has it. So I don't know where Nigeria is trying to copy and paste, but they don't have to copy and paste anything, but they have to look at universally how the military rules apply to people in uniform. Because if you begin to dilute that, it's probably going to affect the morale of those who wear uniform in defense of the country.
All right, Sam, I only have 1 minute, please, and then we'll give another 1 minute to Ejike. One prominent section that was raised was 173, which allows administrative findings like board of inquiry to lead to dismissal without trial. Is this admissible? I mean, is this defensible, rather, in a constitutional democracy? And how do you see this affecting the rights and morale of personnel?
You should, in every democracy, have the right to discipline their staff. For example, the U.S., they need Secretary of War, as sacked some of military officers, sometimes of conduct, sometimes of policy change. So I think we shouldn't control how most institutions have the right to civil service disciplines, sacks civil servants based on tribunal procedure. I think it's a very reasonable proposition. The military has the right to discipline and sack their staff without any resort to civil. But they are being charged for military failure, not for any criminal. They're not being sent to jail. So it's enough trial that they have there. And by the way, we have our military advocates who also appear for them there. And there's a provision that says whether they should appear in civil court. Why should the military advocates appear in civil court? These legislators mix up things they don't understand properly. That doesn't work. You appear in Nigerian court because you're a lawyer, whether you are military or police, you appear. You don't appear because you're a military lawyer. So I think they mix up things there.
Ejike, what direction should this bill, if you accept that it's time for it, should focus more on?
Again, my point is that a discipline, a discipline can be because of insubordination. A discipline can be a war, without official leave or something. Those are disciplines. But if a soldier were to kill another soldier in barracks, do you take him to a civilian court to be tried, or do you court-martial him, and then punish him and sentence him? And so those are the distinctions that needs to be made, because again, the military is totally different. It's not like the police. police, you know, where when things happen, you know, you try, like, again, I'm going to talk about the U.S. because I serve on the Dallas Community Police Oversight Board. I know how those things work. So my point is that in a case of a military, these are people who are armed to defend the country. If they do something in the barracks or while they are in uniform, what punishment do they get?
Yes,
so make a distinction between discipline because of insubordination, not showing up on time, as opposed to criminal act. So the criminal act that a soldier commits, if you commit this act, this is what you're going to face.
All right,
that is where that...
I'm so sorry. I'm told that's
That's fine, thank you.
Yeah, all the time.
No, thank you. It's an interesting conversation to have, and I'm happy they're having this. But the Nigerian public have to weigh in. You know, the Nigerian Bar Association, the people who have interest in rights of people, whether you're in uniform or civilian,
everyone has to be a part.
Yes.
Yeah. Thank you very much, gentlemen, for being here tonight. We appreciate your time.